Imagine showing up to work every single day for almost 2 years, doing your job, managing a medical condition, following your doctor's orders, and then one morning, out of nowhere, your employer pulls you aside and tells you it's time to go. Not because of your performance, not because of budget cuts, but because your body did something your brain couldn't control. That is exactly what happened to one worker in Texas, and what they discovered about their legal rights might completely change how you think about your job security. This situation is more common than most people realize, and the way it plays out, the pressure, the secrecy, the confusion about what comes next, follows a pattern that employees across the country experience every single year. If you or someone you love has a medical condition and holds a job, what you're about to hear could be the most important 12 minutes you spend today. Let's set the scene. A worker in Texas had been employed at their company for roughly a year and 9 months. Before taking this job, they had never experienced a seizure in their life. About 10 months into their employment, they had a seizure at work. This was a significant and frightening event, not just medically, but professionally. They immediately got on medication, and by all accounts, the condition was being managed. They were functional, they were present, they were doing their job. Occasionally, they might miss a dose of their medication, but they would catch up when they remembered, which is honestly something millions of people with chronic conditions deal with every single day. Then, last week, it happened again. A breakthrough seizure, which in medical terms means a seizure that occurs despite someone being on medication, often due to stress, sleep deprivation, a missed dose, or simply the unpredictable nature of epilepsy itself. And the morning after this breakthrough seizure, their employer called them in and made it very clear it was time to resign. Now here's where things get legally complicated and deeply important. The employer was reportedly trying to keep the whole thing quiet, wanting this to be a private, under-the-radar departure. And the employee, understandably shaken by both the medical event and the sudden professional pressure, was left wondering, what are my rights here? Can I collect unemployment? Do I have any legal protections? What do I actually do? Let's walk through exactly what happened, step by step, because the details matter enormously in a situation like this. When this person had their first seizure at work about 10 months ago, that moment legally changed their status under federal law. The Americans with Disabilities Act, commonly known as the ADA, defines a disability as a physical or mental impairment that substantially limits one or more major life activities. Epilepsy, for the vast majority of courts and the Equal Employment Opportunity Commission, qualifies as a disability under the ADA. That first seizure, followed by a diagnosis and a prescription, almost certainly put this employee into a protected class. They just may not have known it. Under the ADA, employers with 15 or more employees are required to provide what's called a reasonable accommodation, meaning they have to work with an employee to find ways to allow them to continue doing their job despite their disability, as long as doing so doesn't create what the law calls an undue hardship on the business. What counts as reasonable? Things like modified schedules, adjusted duties, brief medical leave, or simply allowing someone to continue working while being treated, which is exactly what this employee was already doing. So when this person had their breakthrough seizure last week, and their employer responded the very next morning by asking them to resign, that sequence of events is legally alarming. In employment law, when an employer takes an adverse action, like pushing someone out of their job, immediately following a protected event like a medical episode or a disclosure about a disability, that timing is called suspicious proximity. It suggests that the reason for the termination is the disability itself, which under the ADA is illegal discrimination. Now here's the thing about being asked to resign versus being fired. Employers sometimes prefer to have employees resign because it can muddy the legal waters. If you resign, on the surface it looks voluntary. It can make it harder to claim unemployment benefits. It can make a discrimination case more complicated. This is likely exactly why the employer in this story was trying to keep things quiet and push toward a resignation rather than an outright termination. They may have been trying to protect themselves legally while doing something that is, in all probability, illegal. But here's what this employee needs to understand, and what you need to understand if you're ever in this position. Being pressured or coerced into resigning can still legally be treated as a termination. There is a legal concept called constructive dismissal or constructive discharge. It means that even if you technically submit a resignation, if you were forced to do so under conditions that no reasonable person would tolerate, including being told your job is over because of a medical condition, that resignation can be treated as a firing for legal purposes. That matters enormously for both unemployment claims and any potential discrimination lawsuit. So what about unemployment benefits in Texas? Here's the short answer. It depends heavily on how the separation is characterized. In Texas, you can typically receive unemployment benefits if you are laid off or terminated without cause. If you resign voluntarily, you generally cannot collect unemployment unless you can show good cause for the resignation, and being pressured out of a job due to a medical condition could very well qualify as good cause. The key is documentation. The key is what was actually said, by whom, and whether any of it is in writing. This is why what the employee does in the next few days is absolutely critical. If they have already submitted a resignation, or if they are being pressured to sign anything, they need to stop and think very carefully before putting pen to paper or fingers to keyboard. Signing a resignation letter, particularly one that includes any kind of separation agreement or release of claims, could waive their right to sue for discrimination. Employers often include language in separation agreements that says, in plain English, that you agree not to take any legal action against the company in exchange for a small severance payment. That can be a trap. Here's what this person should do right now. First, do not sign anything without having an employment attorney review it. Many employment lawyers offer free consultations, and cases like this, ADA discrimination cases, are often taken on contingency, meaning the lawyer only gets paid if you win. Second, document everything. Write down exactly what was said, when it was said, who was in the room, and what the tone of the conversation was. Save any emails or text messages related to this situation. The employer wanting to keep things quiet is itself a red flag worth noting. Third, file a charge with the Equal Employment Opportunity Commission. Before you can sue under the ADA in federal court, you first have to file a charge with the EEOC. In Texas, you generally have 300 days from the date of the discriminatory act to file. That clock is already ticking. Fourth, separately, file for unemployment benefits regardless of how the separation was characterized. Let the Texas Workforce Commission sort out the details. Apply. Explain the circumstances. If the employer tries to contest the claim by saying you resigned voluntarily, you can fight back with the facts. Now let's zoom out for a moment, because there are broader lessons here that apply to anyone with a medical condition who is currently employed. First, know your rights before you need them. If you have any diagnosed medical condition, epilepsy, diabetes, a heart condition, a mental health diagnosis, understand that you may already be covered under the ADA. You do not have to wait until a crisis happens to educate yourself about what protections exist. Second, the moment a medical issue arises at work, it is worth consulting with an employment attorney, not because you're looking for a fight, but because you want to know the landscape. You want to understand whether your employer has obligations toward you and whether those obligations are being met. Third, employers do not always know the law, and even when they do, some of them will test you. They will try things that are illegal, hoping you don't know your rights. The quiet pressure, the let's keep this between us, the request to resign without putting the real reason in writing, these are tactics. And knowing that they are tactics is the first step to not falling for them. Fourth, your medical condition does not make you less of an employee, and it does not make you less entitled to dignity and fair treatment in the workplace. The law in this country has specifically and deliberately said that people with disabilities deserve the chance to earn a living, and that employers do not get to take that away simply because someone's body is imperfect. The employee in this story has real options. They may have a genuine discrimination claim. They may be entitled to unemployment benefits. They may have the leverage to negotiate a real severance rather than just walking away with nothing. But all of that depends on what they do in the next few days. If this happened to you, if you've been pushed out of a job, pressured to resign, or treated differently at work because of a medical condition, do not assume you have no options. Consult an employment attorney, file with the EEOC, apply for unemployment, document everything. You have more rights than your employer wants you to know about. If you found this video helpful, subscribe to this channel. We break down real legal situations in plain language because everyone deserves to understand the law, especially when it's the only thing standing between them and losing everything.